బ్యాక్కి వెళ్ళండి.
Words and may I request Honorable Justice Vijayanagar garu, Judge High Court of Andhra Pradesh, to inspire our students.
Good morning to all. Lord Honorable Justice Ram Ganga garu, Lord Honorable Justice Rao Tarnama Rao garu, my teacher, now principal of this institution, I I recollect memory that he taught Hindu law to us when I was studying in law in Vanki Sanardrapa Law College at Balaji. Ram Reddy was my classmate. Thank you one and all. Especially thanks to Mr. Ram Reddy for calling this institution. Previously I had no occasion to this institution to visit. I want to share, with the permission of my lords, my senior colleagues, I want to share some ideas towards advocacy and advocate profession. Thank you. Today I am here asked to advise you about being a lawyer. Yet for a major part of my legal career, I have been a judge. Nevertheless, I am here to tell you what I have done as a lawyer in the beginning days of my career and what I have observed as a judge. Once a student of law, always a student of law. You have to remember that once you step into this profession, you become a student of law for life. You should always cover for knowledge. It is only with such a nature would you be able to succeed in your career. More often than not, you might find a case which might seem hopeless in the beginning. But as you read and research, you will realize there is a hope. There always is a hope. Proficiency in English is vital in legal profession. It is an undeniable fact that Indian law, save for personal laws, is mostly inspired by the English law. True, I need to remind you that the Constitution of India is borrowed from across the globe. When such is the case, it goes without saying that much of commentary on any aspect in law, beginning with the jurisprudence, is in English language. Your research, your drafting and your pleadings will always have to be made in English language. Therefore, your proficiency in English and would directly be proportional to your success in this fraternity. Another important aspect is facts are important. You must know your facts very well. They should be on your fingertips. You should never represent a case without knowing the facts well. It will give a very bad impression to the judge. Another thing is, be creative with your arguments. In this profession, you have the liberty of being creative with your work. If at all you come across a case where you find no arguments, be creative, be analytical, but at the same time, be mindful that more often than not, creative submissions end up become absurd. You have to know where to draw the line. Never be disheartened. Then self-improvement and character building exercises are very important for young lawyers. Remember to be humble. All noble men and women in this profession are humble. For instance, speaking of Nani Valkiwala, senior advocate Iqbal Chawla noted that he was, I quote, a man of genius who never lost the virtue of men, a man of singular simplicity, graced with unbounded warmth and kindness, a man of letters as much as of the law. And quote. Furthermore, you must realize that this nation and its history has always stressed on the importance and prominence of the truth. Remember the logo, truth always trumps, and truth should be your goal. Never mislead the court and never lie to a judge. Always remember what Mahatma Gandhi has said, I quote, the duty of a lawyer is always to place the truth before the judge and to help them to arrive at the truth, never to prove the guilty as an innocent. I quote. As a lawyer, you must also remember that the Constitution is a document of immense prominence. You must look at each statute, each provision, and each situation with the spectacles of Constitution. Only then shall you appreciate the value of human rights, which are at the heart of the Constitution. Let me end by reiterating and re-emphasizing that your allegiance in this profession shall only be true and constitutional. With this, I conclude. I have got some more program with the permission and meeting. The another important aspect I want to share with you is very important thing which I also noticed. My teacher also noticed many times. Except in national law schools and other institutions, the attendance of the students in private organizations is very less.
you don't find that, you don't think that initial stages you may not having importance of the attending the college regularly. But I also personally experienced that unless you attend the college every day, you may not learn the basics of the law. Unless you learn the basic of law, it is just like a weak foundation constructing a fallacious building. It may collapse at any time. Thank you very much for the listening. Thank you.
Thank you very much for giving. His Lordship was a Judge of High Court of Andhra Pradesh on 13/1/2020. And for your encouragement, my dear students, I am telling you, his son and daughter also pursuing law. That is your contemporary, your case. May I request
Mr. Srinivas, District Judge, Mr. Vijayanagar, Principal of the College, members of the audience. I have one advantage over Brother Shamsundar in the sense I was an advocate till about 2.5 years back. So I think I will have a little more to say on these issues. I will not talk about the ethics of the profession. I will not tell you about how noble it is or not. Let us only talk about the practical part of equipping all of you to be able to practice before the courts. This is the purpose of this session. At least that is my understanding of this session. The profession of law is not like engineering or other callings. It is more like the profession of medicine, because this profession requires experience. A raw graduate who may know all the acts by heart, may have read all the commentaries, will still not be a match to an advocate who has 20-30 years of practice, even if he does not know the basics of law. This is because this person who has 20 years experience has built up the skills of advocacy. That skill of advocacy will make the difference between success and failure. For example, let me tell you this. Every judge is a human. He has his prejudices. He or she have their own ideas of what is law, what is not law. So if you go before every judge and argue in the same way, you will not win your cases. You have to study the judge. You have to see what his prejudices are. Now, this is the difficulty all of you will face, because judges, despite having their prejudices and their inclinations, hide them. By sheer experience as judges and by training, they will not move. You will not see any great reaction from them irrespective of what they are thinking. So you have to pick up this ability to read the judges, to know what the judges will like, what they will not like, and to tailor your arguments according to how the judges are reacting. This is the first and most fundamental principle of advocacy that you need to understand. Now, this principle will also require you to be humble. You may be arrogant outside your court, outside the court, but in court you have to be the humblest of persons, because your job is not to score brownie points. Your job is to convince the judge about your client's case. You can do that only if you give up your ego, keep it outside. When you enter the court hall, keep your ego out. Look at what the judge needs. I'll give you a small story on how this works. A famous astrologer once went to the court of the Emperor Akbar and said, I can tell you your future. So the Emperor asked him, just tell me. So he told the Emperor that you have a very long life full of sorrow, you will see all your relatives die before you, etc., etc. The Emperor got very upset and told the astrologer to get out. Then the astrologer went and met Birbal and asked Birbal, what is it, why was the Emperor upset with me? I told him what actually will happen. So Birbal said, please wait for some time, I'll tell you what to do. After a few weeks, Birbal called the astrologer and told him what to say before the Emperor. By then Akbar had forgotten about this man. So when this man came back, he said, you will have a long, peaceful life, you are going to see so many things happen in your life, etc., etc., in a very positive way. Then the Emperor was very happy and gave him a reward. Same story. It's all about how you present. That presentation comes from looking at how the judge is doing. Some judges may insist, unless you shout and scream, some judges may not be convinced about your case. Some judges will get upset if you shout and scream. So you have to tailor everything to that. Now that is the first lesson in advocacy. The second lesson that I would talk about is your knowledge of law and your application of that law. You need to know the law before you step into the court, because the law is what binds everybody, including the judges. You need to understand your case, you need to understand which provision of law will apply and how to apply that law. Quite often, you will realize as you go on into the profession, you will have cases which will have 300, 400 documents, a few, maybe 40, 50 pages of evidence, depositions, but ultimately, at least in my experience, it will be 4 or 5 documents and 4 or 5 pages of that deposition which will decide the case. So you need to be able to pick out those documents and that part of the deposition. Now that will come if you understand the law and you know how to apply these documents and these depositions to the law that you have done. This is my, I would say, second advice. Please understand the law before you go in. Now, nobody can say they know the entire law. That day is past. Today, it is very difficult for anybody to say they know even one single branch of law. Because of the extraordinary increase in the number of journals, the number of judgments being reported, today there is no branch of law that anybody can say he is a master of that branch of law, forget the entire law. So in such a situation, what I would suggest is every time you take up the case, take out the provisions of law and read them. There was a income tax, very senior advocate called Mr. Soli Dastur from Bombay. He was acknowledged as the Pitamaha of income tax law. People used to go from across the country for his advice. Every time somebody would come forward with a issue, he would say, let's look at the law. He is somebody who must have read that provision 100 times. But you would insist, let us take out that provision, let us read it together and see how we can apply that provision to this fact or this situation. Now that will help you go a long way. You need not spend hours, years studying law. But whenever you take a case, take out the provision of law which will apply to that case. But that is a huge difference that will differentiate you from the other lawyers. For example, in a suit for specific performance, one of the requirements is you are supposed to say that I am ready and willing to perform my part of the contract. Sounds very simple, but huge cases have been lost because this one single line was not there in the pleadings. Now this you will understand when you read the Specific Relief Act before you file a suit for specific performance. So read the provision, ensure that whatever is said in the provision is contained in your pleadings. This will make all the difference in winning and losing your case. I can go on these issues, but since time is short, I will stop here. I will only say this. Please remember that you are always a student, you are always learning, and please check the law before you file a case or before you enter the court to argue a case. Because just reading the provision of law, forget the commentary itself, will be of great aid and assistance for you in looking at what you need to do. Thank you.
In case the witness gives false statements, he can be penalized under section 193 of IBC. They may punishment for 7 years. What if they omit to give the answer that questions posed by the police officer? It is also punishable offence. It is under section 179 of IBC. So better not to be found out a witness under section 160, isn't it? Right? So if you found under section 160 as a witness, you must have to tell truth only. Right? Right. And the next, evidentiary value of 161 statements. So if you observe evidentiary value, see here, evidentiary value means the first question arises is whether basing upon that 161 statements, the magistrate will convict the accused person or not. So whether it is a substantial evidence or not, it is not absolute. Because why? Because in our state, not only state, in our IBC and in our procedures, we are having some perception like police are not trustworthy, right? Because the police are recorded the statements, maybe they can record the statements of their own also, right? So 161 statements are not at all.
But one thing you must remember, if anybody makes a false statement, it makes no sense. It can be exempted under some other parameters. So whoever makes intentionally any false statement,
spreading so much of he is spreading so much of